issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 134, Sub 2B, and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In its argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2B of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 Sub 2B of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving SEM a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and then resolve it against the appellants. Issue 3 calls on this